My name is João Pedro Quintais, and I'm an assistant professor at the Institute for Information Law, University of Amsterdam.
My name is Sebastian Schwemer, and I'm an associate professor at the Center for Information and Innovation Law at the University of Copenhagen.
Our interdisciplinary research project is on intermediaries' practices on copyright content moderation. So in particularly, we focus on legal rules and practices surrounding how online platforms moderate copyright protected content. Think of platforms like YouTube, Facebook, Instagram, Twitter, and the like, and of rules, systems, and practices that deal with how content is uploaded by users. Videos, music, images, text is dealt with. Now, examples of moderation would be how potential copyright infringing user-generated content is filtered, taken down, or monetized by the platforms at the requests of rights holders. As for the targets of our research, they are quite broad. Like, first and foremost, we focus on policymakers at European and national level, such as the European Commission and national lawmakers, which are struggling with how to legislate, make policy, and interpret the new and complex provisions that regulate copyright content moderation in EU law. This includes the famous Article 17 of the Copyright in the Digital Single Market Directive, as interpreted by the Court of Justice, as well as the overlapping rules applicable to online platforms in the even newer Digital Services Act. So from this perspective, our research is also useful and timely for courts and legal interpreters, for researchers in this area, and of course for the platforms that are attempting to deal with this new wave of regulations that directly impact how they do business.
So with this research on copyright content moderation, we target a wide audience. As João already mentioned, it's both in the legislative and judicative area, as well as platforms and researchers. But of course, also our research is highly relevant to end users as well as rights holders in this complex ecosystem.
The law on the one hand, and the human and algorithmic systems and practices of platforms on the other hand, in the area of copyright content moderation are extremely complex. It is, however, an area of increased economic and cultural significance, since online platforms have become crucial gateways and conduits for access to culture and expression nowadays. So we attempt to tackle these issues from an interdisciplinary approach and a EU perspective, with the objective to map, understand, and evaluate the impact on access to culture in the digital single market of content moderation of copyright protected content on these platforms. In our view, this is essential not only to make sense of the current regulatory puzzle and real work practices surrounding copyright content moderation, but also if we want to properly assess existing rules and determine desirable outcomes to improve access to culture on these platforms.
The issue of content moderation, and more specifically copyright content moderation, is highly relevant in today's society. This issue is very interesting to explore also because on the one hand, we have the legal rules, but mostly this is an area where the practices and the private regulation of these often very large private online platforms has shaped and emerged as kind of one of the central aspects as to how content moderation works today. The European legislative framework has interactions with that, as well as the technology that is being used in content moderation. And in our project, we're really interested in kind of trying to map and analyze how this interplay works out, with the goal to ultimately come with recommendations as to how this interplay should look in order to facilitate access to culture in the best possible way under the European framework.
We have a number of recommendations aimed mostly at policymakers at EU and national level, at courts, and at platforms. For the European Commission, for example, we consider that our analysis provides support to review and update key elements of its guidance on Article 17 of the new Copyright Directive in a manner that is more consistent with the right to freedom of expression. We identify different aspects where a review would be welcome, for instance, as regards a better definition of what platforms are covered by Article 17, the concrete implications of user rights on those platforms, the limited application of so-called upload filters, the complementary role of complaint and redress mechanisms, and the articulation of Article 17 with the recent Digital Services Act. To the extent applicable, we mirror these recommendations and adjust them to national lawmakers implementing Article 17 into national laws across the European Union. And we also identify important gaps in existing rules that should be object of further research and potentially future legislative intervention. Chief among these are rules on monetization of users' content on platforms and their remuneration, of course, and on transparency and access to data on platforms by researchers.
So for the stakeholders of intermediaries, our research provides valuable input regarding how many of the introduced or suggested rules should be operationalized, which is a core concern. There are also certain aspects that we cover where current legislation is not necessarily covering all ground and leaving certain blind spots, for example, regarding the question of overblocking to some extent and so on, where there's still plenty of room for private intermediaries and platforms to get closer to a access to culture regime that has in mind the balance of the different conflicting fundamental rights.
One common misconception, which our research will hopefully help clarify, is that the rules on online platforms in the Digital Services Act do not apply to the so-called online content sharing service providers regulated by Article 17 of the new Copyright Directive. We argue that they do and show to what extent they do, even if there is still some uncertainty on the topic. Another related misconception, this one more common among some policymakers and members of the public, is that the content recognition tools deployed by platforms, such as so-called upload and re-upload filters, are sophisticated enough to be deployed by different platforms in a manner that is consistent with the law and does not lead to overblocking of lawful content. In fact, due to the matching nature of the technology used, these filters are incapable of recognizing context. This is problematic since freedom of expression exceptions that users benefit from, in which the Court of Justice has called user rights, relate precisely to contextual uses like quotation, caricature, parody, or pastiche. This suggests that the use of these filters to block content uploaded by users that has not been assessed by human moderators must be limited and deployed in a thoughtful and careful manner. All of our reports, publications, and tutorials, as well as blog posts, are available on the reCreating EU website, as well as in our main repository, which is Zenodo. We also have our peer-reviewed articles available on open access on the journals where they're published and on our repositories, including SSRN. Finally, we've made a series of easy-to-read and understandable blog posts, most of which are available both in the reCreating EU website and on the Kluver Copyright blog.
And if you're interested in knowing more about our research, please don't hesitate to reach out to us.